You really think one man deserves 1,600 acres? Patricia Holloway asked with a smile that made everyone in the courtroom glance in my direction. 3 weeks later, she was standing in front of a locked gate, realizing the only road into her neighborhood was no longer available, and everything started with the lawsuit she proudly filed against me. My name is Cole Bennett, and until that morning, I honestly believed my biggest challenge was deciding which pasture needed a new fence before winter. My family had owned those 1,600 acres in western Montana for nearly 80 years. My grandfather bought the property after returning home from military service, and every generation added something meaningful to it. We built barns, restored streams, planted thousands of trees, and carefully maintained miles of gravel roads that crossed our own land. One of those roads happened to continue toward a residential subdivision built decades later, but that had never been my concern. People waved when they drove by, and life stayed simple because everyone respected everyone else's property. That changed the day Patricia became president of the Homeowners Association. She drove a luxury sport utility vehicle that looked polished every single day, wore bright designer outfits that never blended into the landscape, and carried herself like she believed every conversation was already settled before it began. The first time we officially met, she stepped out of her vehicle, looked across my pasture, and said, "You have more land than anyone needs." I laughed because I thought she was making small talk. She wasn't. Over the next several months, letters from the Homeowners Association started appearing in my mailbox. At first they sounded polite. Then they became demanding. Eventually they insisted that the association possessed permanent rights over portions of my ranch because residents had been driving across my property for years. I read every page twice before placing them neatly into a folder. Something about the language felt overly confident, almost rehearsed, as if they expected me to surrender before asking a single question. Instead of arguing, I contacted an attorney who specialized in property law. He listened quietly while flipping through the letters and finally leaned back in his chair. "Don't answer yet," he said. "Let's see what they're really trying to accomplish." That advice changed everything. A few weeks later, the official lawsuit arrived. Patricia and the Homeowners Association claimed that the only practical entrance to their neighborhood had become a permanent legal easement through decades of uninterrupted use. According to the complaint, my ownership should be limited because denying access would supposedly harm the entire community. Friends called after hearing rumors around town. Some thought I would settle quickly to avoid legal expenses. Others assumed the association must have discovered some forgotten agreement hidden in county records. I simply thanked everyone for their concern and kept working on the ranch. Every evening, after feeding horses and checking irrigation lines, I sat at my kitchen table studying maps that dated back farther than I had expected. My attorney gathered surveys, tax records, and historical property documents while reminding me not to react emotionally. "Winning isn't about talking louder," he repeated. "It's about understanding the facts better than the other side." Patricia, however, seemed determined to win the battle before stepping inside a courtroom. She attended county meetings, spoke confidently about protecting homeowners, and acted as though my ranch was standing in the way of progress. Every interview sounded the same. She insisted that no reasonable person should control land that affected hundreds of families. What she never mentioned was that my family had never blocked anyone, charged tolls, or created conflict. We had simply allowed neighbors to pass through with mutual respect. There was one detail almost everyone ignored because it sounded too ordinary to matter. My grandfather had insisted on recording every agreement, every survey adjustment, and every maintenance expense connected to that road. The old binders filled an entire shelf inside a climate-controlled storage room on the ranch. At the time, I had no idea one overlooked document sitting quietly inside those boxes would eventually change everything. But as the court date approached, and Patricia smiled for every camera she could find, I realized confidence and ownership were two very different things, and only one of them could survive when the truth finally reached the courtroom. The week after the lawsuit was filed, I stopped looking at the road as nothing more than a strip of gravel cutting across my ranch. For the first time in my life, I began asking why it existed exactly where it did and who had truly paid for every load of crushed stone spread across it over the decades. My attorney encouraged me to ignore the public statements coming from the Homeowners Association and focus entirely on the history of the property. That sounded simple until I realized how many stories had quietly disappeared with each passing generation. My grandfather rarely spoke about legal matters because, in his words, a handshake used to mean something. Fortunately, he believed paperwork mattered just as much. Every survey, receipt, tax payment, maintenance log, and letter had been carefully stored in heavy binders that filled an old oak cabinet inside the ranch office. I spent several evenings turning brittle pages that smelled faintly of dust and aged paper while the summer sun disappeared behind the western hills. The deeper I searched, the clearer one fact became. My family had never built that road for a neighborhood because the neighborhood did not even exist when the road was constructed. It had originally connected our main barn to grazing fields on the northern side of the ranch. Decades later, a developer purchased neighboring land and asked my grandfather for permission to let construction trucks use the existing road temporarily because it would save months of work. My grandfather agreed, but only after both sides signed a written access agreement that described the arrangement as temporary and entirely revocable. That detail immediately caught my attention because the lawsuit repeatedly described the road as permanent. My attorney smiled for the first time in weeks when I handed him the document. He did not celebrate. Instead, he quietly placed it beside several county maps and said, "This is important, but we still need the complete picture." We continued comparing every recorded survey with aerial photographs taken over several decades. Nothing happened quickly. Every answer seemed to create two new questions, yet every record pointed in the same direction. The Homeowners Association had been treating convenience as though it automatically created ownership. Meanwhile, Patricia Holloway continued presenting herself as the reasonable voice protecting hundreds of families. Local newspapers quoted her saying the association simply wanted to preserve established access for the community. She never mentioned the temporary agreement or the fact that my family had maintained the road at our own expense for decades without asking anyone else to contribute. One afternoon, I drove the entire length of the gravel road, something I had not done in years without stopping to work. Tire tracks stretched toward the subdivision while wildflowers lined both sides. Children rode bicycles near the entrance, neighbors waved to one another, and delivery trucks came and went without thinking about whose land supported every mile of that drive. Watching them reminded me why I had never objected to people using the road. Respect had always existed until someone decided permission was no longer enough. That evening, my attorney called with another discovery. The County Planning Commission still possessed archived meeting minutes from the original subdivision approval. Buried inside hundreds of pages was a discussion mentioning that long-term access would eventually require either purchasing an easement from my family or constructing an independent public entrance. Neither option had ever been completed. Instead, every new board inherited the same assumption that temporary permission had somehow transformed into permanent legal authority. The more we uncovered, the less this case resembled a disagreement over a road. It had become a story about forgotten promises slowly replaced by confident assumptions repeated so many times that people accepted them as fact. Patricia sounded increasingly certain in every interview, while I spent my days gathering evidence that nobody had bothered to read for years. I realized then that winning this case would not depend on dramatic speeches or emotional arguments. It would depend on patiently connecting small pieces of history until the truth became impossible to ignore. And somewhere inside those aging records, I could already sense that one overlooked document remained waiting to change everything when the courtroom doors finally opened. The closer the court date came, the more confident Patricia Holloway became, and that confidence spread through the entire Homeowners Association like it had already won. Their attorney began sending formal notices requesting additional property records, photographs, maintenance logs, and correspondence dating back decades. Every request sounded less like a search for facts and more like an attempt to overwhelm us with paperwork. My attorney never seemed bothered. He answered each request carefully, organized every response, and reminded me that people who truly believe they already own something rarely spent so much effort trying to prove it. Patricia took a different approach outside the courtroom. She attended community meetings, spoke with local reporters, and repeated the same message every chance she had. According to her, the association was simply protecting homeowners from an unreasonable landowner who wanted complete control over everyone else's lives. Hearing my name connected to that story felt strange because I had spent years allowing unrestricted access without charging a single dollar or creating a single obstacle. The facts had not changed. Only the story being told about them had. One afternoon, I noticed two unfamiliar pickup trucks parked beside the gravel road near the northern pasture. Several people wearing reflective safety vests stood beside surveying equipment while taking measurements across sections of my property. I parked nearby, introduced myself, and politely asked what they were doing. The lead surveyor explained that he had been hired by the Homeowners Association to document existing road conditions for the lawsuit. He remained professional and respectful, and after confirming they would remain within the permitted inspection area authorized through legal discovery, I wished them a safe afternoon and drove away. Later that evening, my attorney smiled when I described the encounter. "Let them gather every measurement they want," he said. "Distances do not create ownership." His calm attitude contrasted sharply with the increasingly aggressive tone coming from Patricia. New letters accused me of threatening the future of hundreds of families by refusing to recognize what she repeatedly called an established community right. Yet every document we reviewed told a different story. Historical maps consistently identified the road as part of the Bennett Ranch. Tax records showed my family had paid property taxes on every acre surrounding it for generations. Maintenance invoices confirmed that every load of gravel, every drainage repair, and every culvert replacement had been funded by us alone. Not once did we discover evidence showing the association had accepted financial responsibility for the road it now claimed as its own. Several longtime neighbors quietly reached out to me during those weeks. One elderly rancher remembered helping my grandfather repair washouts after heavy spring storms long before the subdivision existed. Another neighbor recalled watching construction crews ask permission each morning before using the road during the original development. None of those conversations alone would decide the lawsuit, but together they painted a picture that matched the written records almost perfectly. Meanwhile, Patricia continued behaving as though victory was inevitable. She even announced during one public meeting that the court would finally correct what she described as an outdated imbalance between one ranch owner and an entire community. My attorney listened to the recording without saying a word. After it ended, he opened another archive box that had arrived from county storage earlier that day. Inside were engineering drawings, planning correspondence, and several folded documents that had not been reviewed in decades. Most appeared ordinary at first glance, but one envelope immediately caught his attention because it carried the signatures of both my grandfather and the original subdivision developer. He carefully set it aside without opening it. "Not yet," he said quietly. "If this contains what I think it does, everything they have built their case around may begin to collapse before the first witness even finishes testifying." The morning of the hearing arrived with clear skies and the kind of quiet that usually settled over my ranch before sunrise. Instead of checking fences or walking the pastures, I drove toward the county courthouse with a banker box filled with carefully organized records resting on the passenger seat beside me. My attorney had spent weeks preparing every exhibit, every survey, and every historical document in chronological order. He reminded me one last time that patience often carried more weight than emotion inside a courtroom. When we entered, Patricia Holloway was already there, surrounded by several board members from the Homeowners Association. She greeted people confidently, smiled for anyone willing to shake her hand, and carried herself as though the outcome had already been decided. When she noticed me, she offered a brief smile that felt more like a celebration than a greeting. I simply nodded and took my seat. As the proceedings began, the judge explained that the dispute centered on whether the Homeowners Association possessed a permanent legal right to use the road crossing my property. Patricia's attorney stood first and delivered a polished presentation. He argued that residents had relied on the road for many years, that the neighborhood had expanded around that access point, and that removing it would create unnecessary hardship for hundreds of homeowners. Large aerial photographs appeared on display screens showing the gravel road stretching across my ranch toward the subdivision. Looking only at those images, it was easy to understand why someone unfamiliar with the history might assume the association's argument made sense. My attorney remained completely still, taking occasional notes, but offering no interruptions. After nearly an hour of testimony, the judge invited our side to respond. Instead of immediately presenting the oldest records, My attorney began with something much simpler. He introduced property tax statements spanning decades. One after another, they confirmed that every section of land beneath the road had always remained part of Bennett Ranch. Next came maintenance invoices documenting gravel deliveries, drainage improvements, culvert replacements, and seasonal repairs paid entirely by my family. The judge studied each exhibit carefully before asking whether the homeowners association had ever contributed financially to maintaining the roadway. Patricia's attorney answered that such records were unavailable because maintenance responsibility had never been formally discussed. My attorney thanked him politely before moving to the next exhibit. County survey maps followed, each confirming the same property boundaries year after year. The atmosphere inside the courtroom slowly changed. The confidence that had filled the association's table earlier that morning became noticeably quieter. Patricia still sat upright, but the certainty on her face began to soften as more documents consistently pointed in the same direction. Then my attorney requested permission to introduce archive planning records from the original subdivision approval process. Among those records were meeting minutes showing county officials discussing future access options for the development. Several passages specifically referenced negotiating a permanent easement with my family at a later date because no permanent legal access existed at that time. The judge paused longer over those pages than any previous exhibit. Patricia leaned toward her attorney and whispered urgently while he reread the highlighted sections. My attorney did not claim victory or make dramatic statements. Instead, he quietly explained that temporary use and permanent ownership were entirely different legal concepts, and the historical record repeatedly treated them that way. Before the afternoon session ended, he reached into the banker box and carefully removed the sealed envelope we had discovered days earlier. He placed it gently on the evidence table, but did not open it. "Your Honor," he said calmly, "this document deserves its own discussion tomorrow because it directly addresses the agreement both parties have been debating." For the first time since the lawsuit began, Patricia looked at the envelope instead of at me, and I realized the confidence she had carried for months had finally been replaced by uncertainty. When court resumed the following morning, the atmosphere felt completely different from the confidence that had filled the room the day before. Conversations were quieter, reporters took their seats earlier, and even Patricia Holloway appeared more interested in the stack of exhibits on the evidence table than in greeting the members of her homeowners association. My attorney arrived carrying the same banker box, but this time he removed the sealed envelope before the hearing even began and placed it neatly beside his legal pad. The judge immediately asked to continue where we had left off. My attorney stood, explained that the document inside the envelope had been preserved with my grandfather's business records for decades, and requested permission to introduce it into evidence. Once approved, he carefully opened the envelope and removed several original pages bearing the signatures of my grandfather, the original subdivision developer, 2 witnesses, and a county notary. Every page had been dated more than 40 years earlier. The agreement was remarkably straightforward. It granted the developer temporary permission to use the ranch road during construction and until an independent permanent entrance could be completed. The language repeated several times that the permission remained entirely revocable by the property owner and did not create a permanent easement or transfer any ownership interest whatsoever. The courtroom became noticeably quieter as the judge slowly read each page. Patricia's attorney requested a moment to review the document personally before asking several questions about its authenticity. My attorney calmly produced certified copies from county archives together with the original recording references that matched the signatures and dates. A records custodian from the county clerk's office then testified that the archived copies were genuine and had remained in official storage for decades. There was no dramatic argument, no raised voices, and no surprise witness appearing at the last second. Instead, every answer simply reinforced the same historical timeline we had been presenting from the beginning. The developer had intended to build another entrance, but never completed the project. Ownership of the subdivision changed hands several times over the years, and each new management group simply continued using the existing road without revisiting the original agreement. Eventually, temporary permission became accepted as permanent fact because nobody bothered to read the documents that had always existed. Patricia's attorney shifted his argument away from ownership and focused instead on fairness, explaining that hundreds of families had relied on the road for many years and that changing the arrangement would create significant inconvenience. The judge listened respectfully before asking a direct question that immediately changed the discussion. Can you identify any document transferring a permanent legal easement from the Bennett family to the homeowners association? A long silence followed. After reviewing several binders, Patricia's attorney admitted that he could not. The judge then asked whether the association had ever purchased an easement, received one through a recorded deed, or compensated my family for permanent access rights. Again, the answer was no. I glanced toward Patricia for only a moment. The certainty that had defined every public statement she made during the past several months had completely disappeared. She looked down at the agreement as though she were reading it for the first time, perhaps realizing that the foundation of the lawsuit had always rested on assumptions instead of legally recorded rights. Before ending the day's proceedings, the judge thanked both sides for presenting extensive historical evidence and announced that he would hear final legal arguments before issuing a written decision. As we gathered our exhibits, my attorney quietly leaned toward me and smiled for the first time since the lawsuit had begun. "The history never changed," he whispered. "Today the court finally saw it exactly as it happened." The written decision arrived 9 days later in a thick envelope that looked surprisingly ordinary considering how much time, effort, and uncertainty it contained. I carried it into the ranch office without opening it immediately. My attorney had already received his copy electronically, but he insisted we read it together before discussing what came next. When I reached his office, he placed the printed opinion on the conference table and smiled before saying a single word. "Congratulations," he said quietly. The court agreed with the facts. Those 6 words carried more weight than every public statement Patricia Holloway had made over the previous months. We sat down and carefully reviewed every page of the decision. The judge concluded that the homeowners association had failed to prove the existence of a permanent legal easement across my property. The opinion explained that long-term use alone did not erase recorded ownership, especially when written agreements explicitly described the access as temporary and revocable. It also recognized the consistent history of property taxes, maintenance expenses, county records, and the original agreement signed decades earlier. Every major point my attorney had presented appeared in the final decision. The lawsuit was dismissed, and the court confirmed that the road remained entirely within the boundaries of Bennett Ranch. I expected to feel excitement the moment I finished reading the last page, but instead I felt something closer to relief. For months my life had revolved around documents, depositions, maps, and court schedules. Finally, the uncertainty was over. My attorney leaned back in his chair and asked the question I had been avoiding. "What do you want to do now?" I looked out his office window for a moment before answering. "Nothing today." He nodded because he understood exactly what I meant. Winning the case did not require me to make immediate decisions. It simply restored the legal rights my family had always possessed. That afternoon, I returned to the ranch and resumed the work that had been waiting for me. I repaired a section of fence damaged by heavy rain, checked water tanks in the northern pasture, and watched the sunset spread across the same hills my grandfather had known. The road remained busy with neighborhood traffic exactly as it had the week before. I made no attempt to change anything because the purpose of the lawsuit had never been to inconvenience families. It had been about protecting ownership from assumptions presented as legal rights. Meanwhile, Patricia refused to accept the outcome publicly. Local news reported that she described the ruling as disappointing and suggested the homeowners association would evaluate every available option. Yet no appeal was filed during the following weeks. Instead, silence gradually replaced the confident interviews that had filled local headlines earlier in the summer. Residents began asking questions at board meetings about legal expenses, attorney fees, and why the association had pursued a lawsuit built on documents that apparently contradicted its own position. Those conversations never reached my ranch directly, but friends occasionally mentioned them whenever we met in town. I simply listened without adding much. My attorney, however, remained focused on something entirely different. About 2 weeks after the decision, he visited the ranch carrying a folder containing certified copies of the judgment and several recommendations. "The court confirmed your ownership," he explained, spreading the papers across my kitchen table. "But ownership only matters if it is managed properly. He recommended recording additional notices with the county, updating boundary markers where necessary, and reviewing every existing access arrangement on the property so future misunderstandings could be avoided. One recommendation stood apart from the rest. He suggested that now, after the case had officially ended, I should finally decide whether temporary permission to use the road would continue under the same informal understanding that had existed for decades, or whether it was time to establish clear legal boundaries for the future. I did not answer immediately because I already knew that decision would affect hundreds of people who had never personally caused me any trouble. Still, the lawsuit had revealed one undeniable truth. Good intentions could disappear with a single change in leadership, while written agreements remained long after memories faded. As I looked toward the gravel road stretching across my land that evening, I realized the next chapter would not begin inside a courtroom. It would begin at the entrance to my own property, where one simple decision would determine who crossed it, under what conditions, and for how long. For nearly 2 weeks after the judgment, nothing changed on the surface. Cars continued rolling across the gravel road every morning, delivery trucks followed their familiar route, and families came and went as though the lawsuit had never happened. I deliberately left everything exactly as it had been because I wanted time to think before making a decision that would affect more than my own ranch. My attorney never pressured me. Instead, he reminded me that the court had restored my rights, not taken away anyone else's overnight. Whatever you decide, he said during one phone call, make sure it is based on clear rules instead of assumptions. That is how you prevent another lawsuit 20 years from now. Those words stayed with me. I walked the road several evenings in a row, stopping where the gravel entered my property line. The boundary marker had been there for decades, quietly separating public land from private ownership, yet almost nobody noticed it anymore. That was the real problem. Years of routine had slowly replaced written agreements, and convenience had become mistaken for entitlement. I eventually reached a decision that felt both fair and responsible. Before changing anything, my attorney recorded certified copies of the court's judgment with the county and filed updated notices confirming the legal status of the property. We also mailed formal letters to the Homeowners Association explaining that the temporary permission historically extended by my family would officially end 30 days after receipt of the notice unless a new written agreement could be negotiated. The letter was respectful, professional, and free of emotion. It did not threaten anyone or demand money. It simply explained that future access across private property required a properly documented legal arrangement rather than an informal understanding. Patricia Holloway never responded personally. Instead, the Homeowners Association's attorney acknowledged receiving the notice and requested additional time to discuss the matter with the board. 30 days passed without any meaningful proposal. During that period, I continued allowing traffic exactly as before because I had promised my attorney I would honor every deadline we established. When the final day arrived, I hired a licensed fencing contractor and a local gate company that specialized in agricultural properties. They reviewed the survey markers, confirmed every measurement, obtained the required permits where necessary, and began installing a decorative steel entrance several hundred feet inside my property line. Large stone columns framed the new gate, while a clearly visible sign identified the entrance as private property. Nothing blocked any public roadway. The installation remained entirely within my own land, exactly where the recorded surveys placed the boundary. Curious neighbors stopped along the shoulder throughout the day to watch the construction. Several politely asked what was happening, and I explained the situation exactly as the court had recognized it. Most seemed surprised to learn that the road had never belonged to the Homeowners Association. A few admitted they had always assumed it was public because they had used it for so many years. I understood why they believed that. Assumptions become convincing when repeated long enough. 48 hours after construction finished, the gate became operational. Residents leaving the neighborhood discovered that the familiar route now ended at a locked entrance positioned on private property. Traffic quickly backed up near the subdivision while board members attempted to understand what had happened. I remained at the ranch office reviewing invoices when my telephone rang repeatedly throughout the morning. Some callers simply wanted information. Others asked whether the closure was temporary. I answered every question politely, and explained that the homeowners association had received written notice weeks earlier together with an opportunity to negotiate a formal access agreement. By early afternoon, local officials visited the site to review the situation. After examining the recorded surveys, the court judgment, and the location of the new gate, they confirmed that the entrance stood entirely on private property and complied with the applicable requirements. They encouraged everyone involved to continue discussing a long-term solution, but made it clear that the ownership question had already been resolved by the court. Later that evening, I noticed something I had not expected. Instead of directing their frustration toward me, many residents gathered outside the homeowners association clubhouse asking their own board why they had spent months insisting victory was guaranteed while never securing permanent legal access in the first place. Patricia arrived wearing the same confident style that had defined every public appearance throughout the lawsuit, yet this time she faced questions from the very people she claimed to represent. Standing quietly on my porch as the sun disappeared beyond the western hills, I realized the court had settled the legal dispute days earlier, but the consequences of ignoring history were only beginning to unfold. The morning after the gate became fully operational, the atmosphere around the subdivision changed completely. Instead of confident statements from the homeowners association, there were long lines of residents gathering outside the clubhouse before sunrise, hoping someone from the board could explain what would happen next. I watched from a distance only once while driving to a feed supplier in town. The conversations looked serious, but I had no interest in standing nearby or making anyone uncomfortable. My disagreement had never been with the families who lived there. It had always been with the leadership that convinced everyone temporary permission was the same as permanent ownership. By midday, my attorney called with an update. The homeowners association had formally requested a meeting. This time the language in their letter sounded very different from the lawsuit they had filed only months earlier. There were no accusations, no demands, and no claims that the road belonged to them. Instead, the board asked whether I would consider discussing possible long-term access arrangements that could benefit everyone involved. My attorney read the letter twice before placing it on my desk. "Notice what disappeared," he said. "Nobody is talking about entitlement anymore. Now they are talking about cooperation." I agreed to meet, but only after making one condition absolutely clear. Every discussion would take place through attorneys. Every proposal would be written, and every agreement would be properly recorded with the county if one was ever reached. There would be no verbal promises and no assumptions left for another generation to misunderstand. 2 days later, we met inside a neutral conference room at a local law office. Patricia Holloway entered looking noticeably different from the woman who had smiled confidently outside the courtroom weeks earlier. She still wore elegant designer clothing and expensive jewelry, but her expression carried far more exhaustion than confidence. Several homeowners accompanied her, including residents who had lived in the neighborhood for many years. One elderly couple spoke first. They apologized for the conflict, even though they admitted they had never known the true history of the road. I thanked them for their honesty because they had done nothing wrong. They had simply trusted what their board had told them. Patricia remained quiet for much of the meeting before finally acknowledging that the association should have reviewed the historical records more carefully before filing the lawsuit. It was not the dramatic apology some people might expect, but it was the first time she admitted that assumptions had replaced facts. My attorney then presented a simple principle. "Mr. Bennett is not required to provide access," he explained calmly. "However, he is willing to discuss a lawful agreement that respects private ownership while providing certainty for future residents." The room became noticeably calmer after those words. For the first time since this entire dispute began, everyone focused on solving a problem instead of winning an argument. Over the following week, our attorneys exchanged several drafts. We discussed maintenance responsibilities, insurance requirements, speed limits across the ranch, future repairs, emergency access, and clear procedures for resolving disagreements. Every paragraph existed for one purpose: preventing another misunderstanding decades later. While negotiations continued, the residents held another homeowners association meeting. According to several people who attended, board members faced difficult questions about legal expenses, planning decisions, and why they had pursued litigation before examining the original agreements. Patricia eventually announced that she would not seek another term as president once her current service ended. No dramatic speeches followed. She simply admitted that rebuilding trust would require new leadership. Hearing that news gave me no satisfaction because removing one person never solved the underlying issue. Better decisions did. A few evenings later, I stood beside the locked entrance watching the last light fade across the valley. The gravel road looked exactly as it always had, yet everything about it had changed. It was no longer a symbol of conflict. It had become proof that clear records, respectful negotiations, and patience accomplished far more than assumptions ever could. As my attorney finalized what he believed would become the last draft of a permanent agreement, I realized the dispute that had started with a lawsuit was finally moving towards something my grandfather would have appreciated most: a solution built on mutual respect, written clearly enough that nobody would ever have to argue about the same road again. 3 weeks after the first negotiation meeting, the final agreement was ready for everyone to sign. It was not a complicated document filled with impossible demands. Instead, it clearly defined every responsibility that should have been written down decades earlier. The homeowners association would receive a recorded access easement across a specifically surveyed portion of my property. The association would assume financial responsibility for maintaining that section of the road, carry appropriate insurance, respect posted speed limits, and notify me before performing any construction or utility work. Any future changes would require written approval from both parties and would be recorded with the county so that no future board, homeowner, or property owner would ever have to guess what the agreement actually meant. Sitting in the county records office while the final signatures were completed, I thought about my grandfather. He had always believed that clear agreements protected friendships better than uncertain promises. Looking back, he had been right all along. The lawsuit had never become necessary because of one road. It happened because temporary permission slowly transformed into assumed ownership after enough years had passed. Once assumptions replaced written facts, conflict became almost inevitable. Patricia Holloway signed the agreement without saying very much. Before leaving, she walked over to me and quietly admitted that she wished the board had spent even one afternoon reading the old records before filing the lawsuit. I appreciated her honesty because acknowledging a mistake often requires more courage than defending one. We shook hands, wished each other well, and walked away in different directions. That simple moment brought far more closure than any courtroom ruling ever could. A week later, the gate remained in place, but it no longer separated neighbors from one another. Instead, it operated through the new recorded agreement exactly as both sides had accepted. Residents drove across the property once again, this time knowing the arrangement existed because it had been lawfully negotiated rather than simply assumed. Several families even stopped by the ranch during the following months to introduce themselves. Many admitted they had never realized my family had cared for that road for generations without asking for recognition. Those conversations reminded me that most people simply wanted honesty, stability, and respectful neighbors. They had never asked for unnecessary conflict. Life gradually returned to normal. My mornings once again revolved around fences, livestock, equipment maintenance, and watching the sunrise spread across 1,600 acres that had remained in my family for generations. The old binders containing surveys, agreements, and maintenance records returned to their shelves inside the ranch office, but this time I added digital copies stored in multiple secure locations. I hoped nobody would ever need them again. Yet I understood the value of preserving history before memory had a chance to rewrite it. Looking back, the most important victory was never the court's decision. It was proving that facts still mattered. Ownership could not be rewritten simply because enough people repeated the same story for long enough. Respecting another person's property did not weaken a community. It strengthened it because trust only survives when boundaries are understood by everyone involved. The road crossing my ranch still connects neighbors today, but it now carries something more valuable than convenience. It carries a lesson that every future homeowner, board member, and property owner can understand. Assumptions create disputes, while clear agreements create peace. If you had been in my position, would you have reopened access after everything that happened, or would you have made a different decision? I would genuinely enjoy reading your thoughts in the comments because every perspective teaches something valuable. And if you enjoy stories where patience, careful planning, and respect for the law ultimately prevail, I hope you will consider subscribing so you can join me for more stories like this in the future.